As is already indicated, our application is dated 16th of June 2025, the year of the Lord. The substantive prayer sought is prayer B on the face of the application. And that prayer is that the respondent before court be remanded at the Lang'ata police station or any other police station within the Republic of Kenya and Your Honor, the reason being, and this is the justification, that it will enable the applicant herein, the Republic, through the Independent Policing Oversight Authority, to continue and conclude investigations in respect of the facts, the basis of the arrest of the respondent. Your Honor, our application is based on both law and facts. And to be more specific, Articles 24, 29, 49, of the Constitution and Section 36, capital A, of the Criminal Procedure Code. We will also make references to the decision of the High Court of Kenya at Nakuru, Honorable Justice Joel Ngugi, a judge I hold so highly, in the decision of Sudi Oscar Kipchumba versus Republic, and this is Criminal Revision number 208 of 2020. You know, fundamentally, that decision of the learned Justice Ngugi, as he then was, because he now sits at the Court of Appeal, cites and makes reference to the decision of the High Court of Kenya at Milimani, delivered 4 years before it by the learned Justice Luka Kimaru, as he then was as well, because he equally sits at the Court of Appeal, in Michael Rotich versus Republic. And we preempt that the defense are likely to run away with Michael Rotich, so we are going to hit hard on it before they get the chance. You know, in summary, what we are requesting this court to do is to issue an order for what the Constitution calls detention continuing. So that the respondent remains in custody, that's the common name that we call it, custodial orders, for purposes of completion of investigations. You know, cognizant of the limited jurisdiction of this court under Section 8, subsection 2 of the Magistrates Court Act 2015, our references to Article 29 is only in passing and for purposes of laying basis. That every person, I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. Your Honor, in further laying of the basis, that Article 24 of the Constitution allows for limitation of rights. under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification. And where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important to us, informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joel Ngugi J, as he then was, in Sudi Oscar Kipchumba.
The DPP is making submissions. They waive the right of making submissions after we have made our submission, so that once they have done this, they will surrender the business for cross-examination. And they have no right. Procedurally, it is the deponent to be put on the dock, and the deponent is cross-examined. The respondent's lawyers submit, then the state submits. But now it's the reverse. And that's why I'm asking, is my good JV abdicating the role?
My understanding was that he was just laying a basis so that once the deponent comes to the dock, then they can proceed from there. Yeah. So let JB just finish with your laying your basis. I believe it's more or less like an opening statement.
We have done an opening statement.
Yes, let him finish.
Then we're doing an opening statement to lay the basis, yes, and counter what I've been saying. Because he's doing actually an opening step. We'll also be seeking that we also put an opening step and before the court.
So,
Sorry, Your Honor. I do not understand the basis of that argument, because we are arguing our application with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts. So I'm almost done with the law. But sometimes he does that to take me off-road, and he knows I never get off-road. So, Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Joel Ngugi, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial.